Good afternoon, Your Honor. John Calvin, P7477, appearing on behalf of the plaintiff, Douglas Eisenhower. And just to let the court know, Your Honor, Mr. Eisenhower is hard of hearing. He has his hearing aids in, but he may have some difficulty hearing.
We have equipment, so we had known that.
This case is not just a legal dispute. It's a slow-burning emotional collapse that's been building for over 3 decades. What you're about to watch is a 34-year relationship unravel in a courtroom, where law, morality, and personal history collide in ways that are anything but clean. On one side, you have a man trying to reclaim control of his living situation, citing lease obligations and personal boundaries. On the other, a woman who claims loyalty, sacrifice, and years of caregiving, now facing the possibility of losing everything. Here's where it gets complicated. Legally, this isn't a divorce. There's no marriage, no formal spousal protections, no automatic division of assets. That means the court is dealing with a meretricious relationship, a long-term domestic partnership without the legal safety net of marriage. And that changes everything. But the real tension? It's not just about property. It's about control, habits, promises, and the emotional debt that builds over decades. You'll hear allegations of hoarding, financial disputes, broken promises, and conflicting versions of sacrifice. And the judge, Judge Simpson, is about to walk a very tight line between legal authority and human empathy. Stay focused, because what starts as a simple possession request quickly turns into something far deeper, a question of obligation, not legal obligation, but moral responsibility.
Your Honor, in my mock trial in Judge Connor's class, which would have been in 2009, the presiding judge definitely told us some things like which side to sit on, make sure you're standing. I don't know if you know that judge very well, but if I sit down, you can tell Judge Connor it might have been Judge Simpson's fault.
At work for you, sir?
I seem to be able to hear you. Yes, sir.
All right, very good. Okay.
So, Your Honor, the last time we were here, we had a couple of hearings. We were here via Zoom, and we've had some discussion on the record about the length of the parties' relationship. They have had a domestic relationship in excess of 30 years, and the comment that you made, I'm paraphrasing. Basically, you wanted to look Mr. Eisenhower in the eyes and have him tell you why he was doing this. So that's what we've appeared for today. The parties were not married. Mr. Eisenhower is on the lease by himself, and we've given a 30-day notice to quit, and we're asking just for possession. So that's where we stand procedurally.
This is the moment where the case pivots from procedural to personal. Up until now, it sounded like a standard possession request, someone asking the court to remove another person from a property they legally control. But the judge cuts straight through that and asks the real question, why? And that question matters more than anything else in this hearing, because in cases like this, especially without marriage, the court isn't just looking at who's on the lease. It's evaluating credibility, intent, and whether this is being done in good faith or as a reaction to something deeper. Notice how the plaintiff immediately starts building a narrative. He introduces the issue of hoarding. That's strategic. Why? Because hoarding isn't just a lifestyle difference. It can be framed as a legitimate interference with living conditions. What lease compliance and even safety, that strengthens his legal position. But here's the tension. Labeling someone as a hoarder in court can also shift sympathy. It can make the other party appear unstable or unreasonable. And that's a powerful tool in a courtroom setting. Now ask yourself, do you think this is truly about living conditions, or is this a relationship that's finally breaking under pressure?
Why do you want her out?
Why do you want her?
Specifically, Your Honor, it's a compilation of a number of reasons. One of which, and I am not a clinician, I am not trained to being able to evaluate other people in their medical conditions, but Ms. Stoughton has a problem with hoarding, and I have resided with her in numerous locations. We have been evicted from several. We were able to clean out some of them in time so that the eviction didn't go through. But it's cost me quite a bit. The most recent one, I had a problem in 18 with a forklift running over me. I have a settlement that came as a result of that, that gave me a substantial amount of money. But we have moved on. I have taken an apartment in Ann Arbor, in the Ypsilanti, Ann Arbor region. And at the time, she stayed in what was a trailer that we were being evicted from. My daughter came with me, and we decided together, although she is not on the lease. I realized that what I am doing here is rather cruel. It's being
This is one of the most revealing moments in the entire hearing. The plaintiff openly admits that what he's doing feels cruel. That's not something you usually hear in a straightforward eviction-style case. Legally, he may be within his rights. He's on the lease. He has obligations to the landlord. He can argue that excess clutter violates those terms. All of that holds weight. But emotionally, this admission introduces doubt. It signals that he understands the human cost of his decision, and yet, he's proceeding anyway. Then he reinforces his argument with structure. Repeated evictions, inability to control what comes into the home, and lease compliance risks. This is calculated. He's building a pattern. In court, patterns matter more than isolated incidents because they suggest the issue won't resolve itself. But then comes the contradiction. He acknowledges her positive traits, calling her a good person, someone who helps others. That creates a split narrative. She's both a problem and a caretaker. That duality is exactly what makes this case volatile, because now the judge isn't just weighing facts. He's weighing character.
I don't know any other way. We've had this relationship and it's been discussed and talked through numerous times, yet I cannot in any way get her to stop bringing stuff in when I don't want it. I can't stop her from packing my cars with whatever she gets. She's got a good heart. She takes care of people. She works through it's called the Lighthouse in Westland. So she's a very good person, and I have nothing against that. But I've got to take into consideration that at 78, I've got a few more years left, and I think I have to look.
34 of those that were spent, 34 of those that were spent with her, correct?
I'm sorry?
34 of those 78 years that were spent with her.
Yes, sir. 34 of the 78 has been spent with her. There have been times when I felt that I should have upped the relationship or pursued what I'm pursuing right now. That was back in 2015 in Sterling Heights, but I never went through with the paperwork at that time. We managed to make it this far. I fully well understand that, but now that I am in a new location, we've got stuff coming in here again. And I've got terms to my lease that I have obligations to. I can't justify to the lease or to the apartment complex my keeping or storing materials in there that I don't want in there. I can get her to stop. Perchance maybe there would be a continuation, but I have no designs on any other relationship. I just want to, I don't want to be fearful of somebody coming to the door and saying, why is this here? Why is that there? I have a recently purchased and have a 2018 Lincoln Continental that went over to Varsity. I had work that needed to be done on it. It needed to be emptied out for the technician to effect the repairs, and we received a phone call. I gave them permission to throw away what they considered to be garbage, and was asked, can we throw it away?
This is where the conflict escalates from lifestyle differences to personal violation. The plaintiff describes giving permission to discard items from his car, only to later discover that deeply personal belongings were gone. From a legal standpoint, this introduces a question of consent and scope. He gave permission, yes, but did that permission extend to sentimental or irreplaceable items? That's a gray area. And in court, gray areas are dangerous because they open the door to interpretation rather than clear judgment. Emotionally, though, this hits much harder. Losing a picture of your parents isn't about clutter, it's about identity, memory, and respect. And when he says, "I can't live like this," that's no longer about objects. That's about control being taken away from him. But here's the flip side. What if he's making unilateral decisions, like allowing others to throw things away? Then the question becomes, is he also contributing to the breakdown? Who crossed the line first here? The person bringing things in, or the person throwing things out without full clarity?
So I assume at that point that it was garbage, it was in the car. I gave them that permission, and when I came home, pictures on my wall are gone. Picture of my parents in my bedroom is gone. I have no idea where that's at. I can't live like this. And this is why, if there was a way of resolving it in a common fashion where we could talk and negotiate and work together on clearing this up, it'd be fine. But we can't. I've tried, and it's just not gonna work.
Ms. Totten, what do you want to tell me?
What
What do you want to tell me?
I think it boils down to is he has enough to put me in somewhere. Like he said, he got a settlement. The whole time I took care of him, I made sure he's got his leg and his foot because of me. They wanted to amputate. I fought for it. I took care of it. I kept it clean. And he kept telling me the whole time I was taking care of him that he would get me a house and give me so much for allowance. But then his son, who he hasn't seen in 17 years, said, "Oh, Dad, I got a financial advisor for you." So all the money is in Florida, not making any money. And yeah, I think I'll be Mother Teresa, but I am not doing like I did. I gave up all my ministry. I'm not doing animal rescue anymore. I barely go to the lighthouse. On occasion, maybe twice a month now to help them. Them ladies need help. I know not to bring my ministry in, but he's gone the opposite end. Like I said, I'm allowed to bring 2 days worth of food in the house. If I don't need it, he throws it away. And as far as varsity, when I called varsity and said what needed to be cleaned up, so all he had to do was tell those technicians, because I didn't know, is to take the stuff and put it in the back seat. But he didn't. He told them to throw it away. This is the first time I ever took anything of his, and I'm not like him. I wish I could be. I didn't throw those pictures away. I have them. They're safe. As I don't have it in me to take other people's belongings and throw it away, but he thinks nothing of it. Like I said before, I house sit, I people sit, I pet sit to earn some money. And when I'm gone and I come back, he's cleaned out stuff of mine, even food out of the freezer that is not gone bad, steaks, hamburger, or whatever. You don't want it in the house, he throws it out. But he's got his own personal refrigerator in his room. And I've asked him before, write me a contract. Well, how exactly do you want me to live? Exactly. Well, I can't.
Hold on.
Well,
Hold
why
on.
not? Right?
Hold on. You guys have been together 34 years.
Yes, we have.
This is where Judge Simpson steps in and reframes the entire case. Instead of focusing strictly on legal arguments, he zooms out and highlights the passage of time, 34 years. That's not just context, that's pressure. Because with that kind of history, the court is no longer dealing with strangers or even casual partners. It's dealing with a shared life. The judge introduces a critical concept: people change. And while that sounds simple, it has serious implications. If both individuals have evolved, physically, emotionally, mentally, then the expectations they once had may no longer apply. But here's the deeper layer. He's subtly challenging both sides. To the plaintiff, are you justified in walking away now? To the defendant, can you rely on the past to secure your future? This moment also signals something important. The judge is not going to treat this as a cold, technical case. He's going to explore the human dimension. And that means both sides are about to face harder questions than they expected.
I would imagine that if you were to look back 30 years ago, the two of you are not the same people that you were. Right?
Yeah, we're older.
And you changed.
Yeah, I have MS now, so, and he knows stress brings out flare up. I'm worried about that.
Okay. And so,
I'm sorry.
He's having a hard time hearing.
oh, are you, if you turn up the volume on it,
I kind of caught part of what she was saying about monies and promissories, things that my.
she's not talking, you know what, sir?
I'm
Can we
sorry.
make sure that it turned up for
Yeah.
He understands, Doug. I don't want to leave you, our daughter, our pets.
That's better.
him? Okay, all
Yes,
right, there you go.
I can hear you. Thank you, sir.
Okay, look, you guys aren't the same that you were 30 years ago.
Yes,
People grow older together, they change. No two ways about it. And, you know, although you didn't give those vows, I don't think you guys just said at some point we just get the chance to just go.
Your Honor, if I could, the first time I spoke with Mr. Eisenhower and several times since, he expressed to me how difficult this was going to be for him and that he was going to rely on me to do a lot of the heavy lifting there because it was difficult for him. He's tried before and failed to even proceed, and that he was going to be relying on me. And although you and I both know very well, we wear a lawyer hats, we're also people. Those hats come off. So I know the emotional side of this. I know the difficulties that are involved in this. But at the same time, as Mr. Eisenhower's advocate and as his attorney, I have to remind the court that this is a meretricious relationship. And if the parties, either one of them, wanted the protections of marriage, they have to accept the burdens of marriage.
This is the legal backbone of the entire case. The attorney introduces the term meretricious relationship, and that single phrase defines the limits of what the court can and cannot do. In simple terms, it means a long-term domestic partnership without the legal protections of marriage. Why does that matter? Because in the eyes of the law, duration alone does not create entitlement. 34 years together may feel like a marriage, but without formal recognition, the legal system treats it very differently. There's no automatic right to shared assets, no guaranteed support, no built-in obligation to provide housing. Notice how the attorney carefully separates emotion from law. He even admits that, as a person, he understands the emotional weight, but as an advocate, his duty is to his client's legal rights. That distinction is critical. In court, empathy can influence tone, but it rarely overrides legal structure. But here's where tension builds. The judge immediately pushes back, not on the law, but on the consequences. If one party walks away with financial stability while the other is left vulnerable, the court starts asking uncomfortable questions about fairness. So now the case shifts again. It's no longer just about rights, it's about imbalance.
My parents, ironically, were married for 35 years, had 10 kids, and then divorced. Their situation when they split up after 35 years was vastly different than the situation here. And I understand that. And Mr. Eisenhower has expressed to me, and their daughter is here as well. The court would like to hear from her. But he's expressed to me this does not necessarily mean the end of all relationship and the end of us trying to do what
I
we
get you,
can.
counsel, but let me ask you this. How's she supposed to take care of herself?
Your Honor, I understand that, but how is he supposed to take care of himself is and again, as a lawyer, my position is different than as a person. I understand that as a person, but as his advocate, he needs to take care of himself.
But if one has all the power dynamics, money, everything else, then I don't know that I necessarily ask him that question. I ask what would be the side that doesn't have that. How are they supposed to do that?
This is a direct confrontation between legal logic and moral responsibility. The judge is no longer satisfied with technical arguments. He's asking a practical human question. How is she supposed to survive? And that question cuts deeper than anything presented so far. Because while the law may allow the plaintiff to reclaim possession, it does not automatically resolve the aftermath. Where does she go? How does she support herself? What happens to someone who has limited income, declining health, and no clear safety net? The defendant responds by outlining her situation: odd jobs, denied disability, upcoming medical procedures. This isn't just background information, it's a vulnerability profile. And in court, vulnerability can influence how aggressively a judge applies discretionary powers. Then comes the emotional escalation. Now she references promises, being taken care of if things got worse. Again, legally weak without documentation, but emotionally potent. Here's the tension point. Should verbal commitments made over decades carry any weight when someone's survival is at stake? Or does the court strictly enforce what can be proven?
How's that supposed to happen? Are you working?
No, I just do odd jobs. You know, like I said, I house sit, people sit, pets sit.
So how,
And I got denied my disability because my MS, I'm still pretty much good, but I'm supposed to have both my knees replaced. I'm supposed to have neck surgery, and I can't do any of that, even though he said if I got bad, take care of me.
If I can,
brief thing.
I fully understand that she is not well.
Do you?
Yes, sir, I do.
Do you really though?
Your Honor.
Does 34 years mean anything to you in terms of maybe that obligation, irrespective of a marriage license, irrespective of anything along those lines, maybe some other moral obligation that I just take care of this person? Because I'm sure she has seen you at your ugly side and she's probably dealt with you. And now when it gets to the point where that's this for her, where she may be struggling, where let's say she is a hoarder. Let's say all of those things, you just bail. So do you really?
I feel I do, yes, and I want to at least tag this on and the fact that my asking her, pleading with her not to bring things in, I don't need.
Let me ask you this before you just drone on. Have you said to her, maybe let's go someplace and have somebody else help us talk about this? I mean, the first thing out of your mouth is you said she's a hoarder. Ma'am, do you think you're a hoarder?
During the pandemic, I'll say, yeah, probably, because I was still using our house as a charity drop-off site. But then he says he has failed. He knows how to stack and consolidate up to the ceiling, and then I can't touch it to sort it and get rid of it, and he takes the keys from me.
Okay, all right.
But I'm not doing that anymore, that's what I'm saying.
Okay, but have you guys thought about doing that?
This is an attempt to de-escalate the situation, but it also reveals how far gone the relationship really is. The judge suggests counseling, communication, mediation, intervention. These are tools typically used when there's still a willingness to repair something. But listen carefully to the responses. There's resistance, defensiveness, and interruption. Instead of engaging with the idea of resolution, both sides revert back to accusations and justifications. The plaintiff focuses on control, what should or shouldn't be brought into the home. The defendant focuses on restriction, being limited, monitored, unable to act freely. These are not compatible positions. One demands order, the other feels constrained. And then the judge steps in again, shutting down what he perceives as bad-mouthing. That's critical. It shows the court is losing patience with repetitive blame and wants constructive direction. At this stage, it becomes clear that reconciliation is unlikely. The issue is no longer whether they can fix the relationship. It's how the court will separate them in a way that is legally sound but not unnecessarily harmful.
Of getting counseling to.
Well, or at least, every couple goes to a point where while they're all sitting there together, that all of a sudden you look at that person, I don't know who the heck that person is. I don't understand them. I don't understand why this is happening. I don't understand why that's happening. And maybe you guys reached it at a much later point, but have you even tried that?
I must admit though that I am fearful of her because any efforts on my part to take anything from the apartment that I feel does not belong there, and ask that it not be brought in. If I pick it up and head to the door to get rid of it, all hell's gonna break loose, I guarantee you. Excuse
I
me,
didn't ask that.
I'm sorry.
I didn't ask that. I don't know why you feel a need to try to badmouth her. I didn't ask that.
Judge, I think he's just trying to make clear, and as I said, the couple's daughter is here. And importantly to know, she's here in support of her father, which is, I'm sure, extremely difficult for her.
I know it is.
And I know it's difficult for Doug, and it's difficult for all of them. I'm not discounting the difficulty for Ms. Houghton. But legally, he has a right to do what he's doing. He's gone as long as.
Counsel, I've got a whole bunch of equitable powers I could use too. So if we want to talk legal, let's go.
I certainly understand that, and I understand the vastness of the equitable issues here. But at the same time, he's the fact that he needed this couldn't be counted against him. That goes two ways. Yes, the relationship has gone this long, but he's also gone this long in extending his understanding and his patience, and has done what he can, and he's reached the point where he said, I can't do it. And again, separating the lawyer and the person, I can understand the difficulties with that, but at the same time, I have to support my client, and I think what he's doing is what he needs to do.
When is the lease up on this unit?
When does your lease expire on the unit?
The lease expires, I believe, in the first part of January of 24. It's on a 1-year lease.
And who's in the unit right now? All three of you?
Yes, and 3 pets.
She is in there with us, yes, at this time, which makes it.
She
times up.
is in there with us. My God. Your trial matter. I'll set trial in this matter. I think that there are issues that Ms. Stratton certainly can raise. Ma'am, you'll have to file a written response to the pleadings. You'll have to file that within the next, I'll give you some time to get that done. 27th. You have to file that by August 15th, 2023. Written pleadings explaining your side of the story. All right. I'll set non-jury trial. What day?
Monday, September 25th.
Non-jury trial, September 25th, 2023 at what time? 9 a.m.? 9 a.m. in person. Okay.
I'm trying to confirm as quickly as I can. I don't think I have any.
Well, if you do, I can go to October.
I don't think I do, Your Honor. I'm just pretty sure.
Okay.
I'm pretty sure that I do not. No.
Okay.
And what time, Your Honor?
9 a.m.
9 a.m.
in person. Yep. Can't wait.
Thank you.
Thank you.
This is the procedural close, but it carries significant weight. The judge sets the case for trial, giving the defendant time to formally respond and present her side in writing. That means this is far from over. What we've seen so far is just the surface, an initial hearing exposing the emotional and legal framework of the dispute. By scheduling a non-jury trial, the judge is signaling that this case requires deeper examination. Evidence, documentation, credibility, all of that will be tested. And importantly, the defendant now has an opportunity to raise any equitable claims she may have, even if they fall outside traditional legal protections. What stands out most is how this case sits at the intersection of law and life. Legally, the plaintiff has a strong position, but emotionally and ethically, the situation is far more complex. 34 years of shared history cannot be easily separated into mine and yours. The final outcome will likely depend on how convincingly each side can support their narrative, not just with words, but with evidence. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.